Welcome to NACD Board Vision, where leading boardroom advisors, governance professionals, and seasoned directors discuss critical issues related to your responsibilities in the boardroom.
Welcome to NACD Board Vision. I'm Peter Gleason, Managing Director and Chief Financial Officer for the National Association of Corporate Directors. I'm joined again today by Don Keller from PwC's Center for Board Governance. Welcome back, Don. It's great to have you join us today.
Thanks, Peter. It's great to be here.
Don, in this episode, we'd like to focus on the status of proxy access. As you know, Dodd-Frank gave the SEC the authority to mandate proxy access, and the SEC adopted Rule 14a-11 in August 2010. The new rule would have allowed qualifying long-term shareholders to nominate a limited number of directors in addition to the company's nominees and to include them in the proxy materials of the company. If a shareholder met the ownership and holding criteria, all they had to do was provide disclosure regarding the nominee and the nominating shareholders to make a certification that they didn't seek a change of control at the company.
Well, that's right, Peter. But before the rule became effective in November 2010, the Business Roundtable and the U.S. Chamber of Commerce sued to challenge the rule, arguing that the SEC violated the Administrative Procedure Act, which requires the SEC to meet certain compliance standards in its rules. The Business Roundtable and the Chamber also requested a stay on the effectiveness of the rule pending outcome of the legal review, which the SEC granted. The court made its ruling in this year in July, siding with the plaintiffs against the SEC.
Don, we talked about this challenge by the BRT and the Chamber on an earlier episode of Board Vision. When the challenge to the SEC was made, it didn't seem like it was going to have the result that it eventually did, and many people were surprised that the decision came down like it did from the Circuit Court. Let's focus on this for a minute. What was the court's rationale for coming to its decision?
Well, on July 22nd, the court vacated the mandatory proxy access rule 14a-11. They found that the SEC acted in what the court called an arbitrary and capricious way in adopting the rule. The court determined that the SEC underestimated the costs but potentially overstated the benefits, failed to fully assess the economic effects of mandatory proxy access on companies, and did not factor in the issues that were raised in over 500 comment letters. In addition, the court determined that the SEC did not adequately evaluate the costs that companies could face from use of the rule by shareholders with special interests, for example, union and government pension funds, to pursue self-interested objectives unrelated to long-term shareholder value creation.
Those were some pretty strong words that the court used, arbitrary and capricious. And overall, this was a pretty pointed decision by the court. Obviously, the SEC, as well as many in the investor community, are quite disappointed in the outcome.
Well, the SEC certainly expressed initial disappointment and is considering its options. One approach would have been to seek an appeal of the ruling, but the SEC indicated on September 7th that they would not pursue that path. As an alternative, the Commission could restart the rulemaking process to address the court's concerns. Chairman Shapiro has left this door open. Keep in mind, though, the SEC has its hands full with the other rulemaking mandated by the Dodd-Frank Act, not to mention its other duties. Tackling mandatory proxy access in the very near future seems unlikely when they are already deeply involved in those other rulemaking projects. In time, the SEC may return to this issue and indicated they are committed to finding a way to make it easier for shareholders to nominate board candidates. In any event, the process will likely take years. The SEC will have to conduct additional studies, propose rules again, and almost certainly face another court challenge. The other interesting aspect of the court's decision is whether it could open the door for challenges to the other provisions of the Dodd-Frank Act, such as conflict minerals or compensation disclosures.
Don, in our comment letters to the SEC on proxy access, we were opposed to mandatory access, or Rule 14a-11, as it was proposed. But we supported a system where the shareholders get to decide on a company-by-company basis, what's commonly referred to as private ordering. Since the court's ruling came out, I've spoken to several directors who have interpreted the ruling to mean that they no longer have to worry about proxy access, at least in the short term. While that's true in terms of mandatory access, let's break this down a little so the audience knows where this all stands.
Sure, Peter. While mandatory proxy access was set aside by the court for now, there's another way for proxy access to be implemented. As you know, there are two approaches to proxy access. One was the new Dodd-Frank Rule 14a-11, which we've just discussed. The other was an SEC amendment to an existing Rule 14A8. The court's ruling did not impact the latter rule, which gave shareholders the ability to pursue proxy access on a company-by-company basis by having the company's bylaws changed. These Rule 14A8 amendments, which were included in the SEC stay but were not challenged in court, enable shareholders to first submit proposals to change the company's bylaws regarding director nominating procedures and have these proposals included in proxy materials subject to certain restrictions. Second, if the proposal is successful and the bylaws are changed, shareholders could then, in the next year, propose director nominees for inclusion in the company's proxy statement. Absent further action by the SEC, this 14A8 rule is expected to take effect on September 13th of this year.
This kind of private ordering allows solutions based on the circumstances of the company. And it's not as though 14A8 would put every company in play. The process you describe is far from easy to achieve and will likely take a considerable amount of time and effort.
Well, Peter, I agree with that. It certainly could be a significant undertaking to get approval to amend bylaws.
So, if we go down this path and private ordering rules the day, we'll be dealing with shareholder proposals to start the ball rolling. It doesn't take much in terms of ownership and holding requirements for potential shareholder proposals, even on something like proxy access.
Well, that's true. It's a fairly low standard. Under the amended form of Rule 14A8, a shareholder would need to own only $2,000 worth of stock and have held it for 1 year to submit a shareholder proposal, subject to certain guidelines.
Okay, let's hit a few takeaways for the audience about what they can be doing now in terms of proxy access as we move forward.
Well, I think there are a few things that boards should seriously consider. Directors should anticipate the possibility that there could be potential 14A8 proxy access proposals, especially since Delaware state law already allows bylaws to include a proxy access provision. In addition, public companies without robust advance notice requirements, say 90 to 120 days prior to the date of the previous year's annual meeting, might consider amending their bylaws to provide a more effective advance notice mechanism for shareholder proposals. Also, boards may want to review and consider the adequacy of their nominating committee charters and processes, their bylaws around director qualifications, and their governor's policies around director age or term limits. Finally, directors need to ensure that there's year-round shareholder engagement to identify and address concerns. Ongoing shareholder dialogue could go a long way to head off possible shareholder proposals related to proxy access and other governance matters.
I think these are very good consideration for boards. It's important to recognize that proxy access is still very much alive. We will certainly keep our fingers on the pulse of this emerging issue and update you on any new developments. Well, that wraps up another episode of NACD's Board Vision. On behalf of PwC and the National Association of Corporate Directors, I'm Peter Gleason, and thanks for joining us.